Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, August 25th, 2021. The time's 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janecka, as well as our General Counsel, Mary Smith. I believe we're joined on the line by our Public Interest Counsel, Mr. McWhirter. Are you there this morning?
Good morning. I am here.
Good morning. And we're also joined today by a professional Spanish language interpreter for item 28. Ms. Damasi, are you on the line? Can you hear us?
Yes, I can hear you loud and clear.
Wonderful. Good morning. Ms. Damasi, I understand that you're going to provide us some information regarding connecting to our Spanish conference line, and this information will also be shown on our webinar screen.
Correct, Mr. Burson. Las personas que deseen escuchar o participar en la reunión en español pueden llamar al número de teléfono 844-368-7161 e ingresar el código de acceso 904535 y el símbolo de número o símbolo de gato. Nuevamente, las personas que deseen escuchar o participar en la reunión en español pueden llamar al número de teléfono 844-368-7161 e ingresar el código de acceso 904535 y el símbolo de número o símbolo de gato. Thank you so much.
Thank you, Ms. Damasi. Appreciate that. I'd also like to let folks know that this is, again, a hybrid meeting today, meaning that most of the participants are joining us virtually. So I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the agenda online, and that link is available on our agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, the item that you'd like to comment on, and we will do our best to accommodate that request. For those making presentations, please begin your presentation only when I or our General Counsel have asked you to begin speaking, and please remember to check your line and make sure it's not muted. Colleagues, we have a very full agenda today, but before we get going, I have to mention that August is retirement season, and at the risk of omitting people, and I'm certain I'll do that, and apologies for that, but I do want to recognize Robert Martinez, Trish Duran, and Stephen Haygood for their many years of outstanding service to this agency and to our fellow Texans. We're grateful for your service, and we wish you wonderful things in the next chapter. I'll invite you to pile on if you'd like to. Commissioner Lindley?
I completely second those comments. Those three are serve big roles at the agency, not to discount anyone else that's retiring this month. Between the three of them, I'd argue that's probably almost about, close to 100 years of institutional knowledge, and we'll figure it out. We'll be able to move on, but they will be missed. So wish the best to them.
Thank you. Commissioner Janecka.
I don't think I can add too much more to the kind words y'all have both stated that I really agree with, but I think hearing those three names brought back so many professional and personal memories. I'm still trying to grapple with any concise comment. I'm as in grief still about the loss of institutional knowledge our agency is going to encounter, as I'm excited for each of them for their next adventures, but also for what growing pains we'll get to go through as an agency in their absence, and part that's where I've grown fonder about some of my colleagues who've left over the years as well. So look forward to being even more regretful of y'all's departures.
Thank you, Commissioner Janecka. All right, well, let's get to the docket. The first item is Old Business 1, and we're actually going to take that up right after item 9 and before our new business enforcement docket. That's going to be a little bit more efficient for our enforcement staff. And so with that, Ms. Smith, I'll ask you to please call item 1.
Item 1 is the consideration of a petition filed by Finch FP Ltd. For the creation of Lakeview Municipal Utility District Number 1 of Ellis County. The parties have been notified that the commissioners will not take oral argument, but may ask questions.
And just a little program note, Finch FP Limited has actually the first 3 items are on our agenda this morning. They're all MUD petitions. They're similar but a little different, so we're going to take them up separately. But as to MUD number 1, and that's item 1, colleagues, as you're well aware, requests for hearings on MUD petitions are a little different from our typical House Bill 801 hearings in that we do not identify and refer specific issues of fact. It's a one-step analysis, and the question is whether the requester has met the procedural and substantive requirements to be entitled to a hearing. And these include a timely request that identifies the requester's location and distance relative to the activity that's the subject of the petition, and a statement of how the requester will be affected in a manner different from the general public. And if the requester does timely identify a personal justiciable issue that's relevant material to the criteria that are set forth in Texas Water Code on which the commission evaluates MUD petitions, in other words, it's got to be relevant to our jurisdiction and our evaluation, then they can be considered an affected person entitled to a hearing. So on this first item, we have well over 100 requesters, and just to cut to the chase, I suggest that we grant the requests of Ellis County and the city of Waxahachie, and that we deny the remaining requests. The county and city's requests were timely. The county stated its interest in groundwater and water quality, and the city has raised concerns about regionalization and the availability of comparable services. And since the proposed MUD would be within the county and the ETJ of the city, these interests are personal to and within the legal authority of these local governmental entities. The remaining requests failed for one or more of the following reasons. They were not submitted until after the deadline, which in this case was April 16, 2021. They did not identify the requester's location. They did not identify a personal justiciable issue, either by raising only generalized issues or concerns that are not germane to the commission's consideration of the petition, or they identified no concerns at all. And finally, and this may have been the biggest failure point, that is that the requester simply resides too far from the district's boundaries to be affected in a manner different from the general public. And we'll see these same reasons for denial cropping up across the next 2 items as well. So that's my take. Commissioner Lindley, how do you see it?
I came down the same way with being comfortable with granting the hearing to Ellis County and the city of Waxahachie.
Thank you. Commissioner Janeka.
Likewise.
I think we're ready for a motion.
I have one. I would move that we grant the hearing request of Ellis County and the city of Waxahachie, refer the matter to SOA for a contested case hearing on the petition, and refer the matter to the, we didn't discuss this, but I'm going to include it in my motion, refer the matter to the commission's alternative dispute resolution program to run concurrently with SOA's scheduling process.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 2 is the consideration of a petition by Finch FP Limited for the creation of Lakeview Municipal Utility District Number 2 of Ellis County. The parties have been notified that the commission will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. So colleagues, as I mentioned, this item is similar to item 1. This is, of course, MUD number 2, as we just heard, and the same requirements or criteria for evaluating hearing requests pertain to this item. And again, we have well over 100 hearing requests. On this item, I would grant the hearing request by the county and city. Both filed timely requests, and again, the proposed MUD would be located, and this proposed MUD is a little bit different. They each are a little different, but this one would also be within the county and the ETJ of the city. Ellis County, for its part, identified several interests within its statutory authority that may be affected by the creation of the district, and it also specifically identified those statutory powers. The city of Waxahachie likewise raised numerous issues that are relevant to the application and related to its authority, including, just to choose a couple of examples, the issues of regionalization and also need. In addition to the county and the city, I would grant the requests of, and I'm going to try to do this slowly so you can cross-reference. since I'm speed talking this morning, I would grant the request of Christopher and Corey Dillo, Travis Dillo, William Kuntz, Christy Picos, Tabitha Tricomi Rogers, as well as some of those who joined Vicky Dillo's requests, and I'll name them later. But let me address this group of requesters. Christopher and Corey Dillo expressed concern about water drainage, which is a relevant factor under Texas Water Code Section 54.021B3. And given that they are located just 0.3 of a mile from the proposed district's nearest boundary, I would consider this to be a personal justiciable issue. Travis Dillo expressed the same drainage concern and is located a half mile from the boundary, so I would consider him an affected person as well. The same goes for William Kuntz, who's located 0.4 of a mile away, and Tabitha Tricomi Rogers, who's also located approximately 0.4 of a mile away. Christy Picos expressed a different concern, a concern about water quality, but that's also a relevant factor under Section 54.021B3. She's located 0.2 of a mile from the boundary and therefore an affected person. Turning to Vicky Dillo, she and not all but some of the folks who joined in her request have also demonstrated that they are affected persons entitled to a hearing. Some of those who joined Ms. Dillo's request filed additional separate requests that were insufficient to qualify for a hearing, but were saved by joining in Ms. Dillo's timely and well-articulated request. Ms. Dillo in the joint request cited concerns about drainage, which, as we've discussed, is squarely within Section 54.021B3. And so really whether those joining Ms. Dillo are affected or not really turns on their proximity to the district. And given the potential impact of drainage from the proposed mud, I think it's reasonable to include requesters within a mile from the district's boundaries. And these would include Vicky Dillo, of course, as well as Kyle and Megan Dillo, Brandon and Paula Lee, Kenneth and Sharon Plunkett, Tabitha Faulkner, Tracy Evett, Gary Reed, Stacy Reed, William Rogers, Mike Ferran, Daniel Frise, Stephanie Frise, Randy Rogers, Casey Rogers, John Boswell, and Monica Hall. And I would deny the remaining requests for the same reasons that I outlined in my discussion of item 1. So let me pause there and see if we came out in the same place on the names.
I appreciate your detailed description of your analysis. I think you've captured all the relevant factors, and I believe I followed all the names as well. I'm just noticing now that the list that I'd had, unfortunately, is not in alphabetical order either.
I only had one question real quick, if you want to indulge, I guess. I wasn't sure. I have Kenneth Hall and Kenneth Hall Sr. and Ann Hall on my list, and I wasn't sure if you had said their names in one of your groupings. I know you listed Monica
I've got
Hall.
Monica Hall.
I think
Yeah.
those
But
were
I-
included as petitioners on that Miss
Okay.
Dillo's, Vicky Dillo's.
I left them out, which is my error, perhaps.
Well,
Do we-
as long as they're captured in the motion, that's what I would.
They do appear on my list.
Okay.
Who I consider I would support as affected.
Kenneth Hall Sr. and Ann Hall. Yeah, I did not include those in my analysis, but colleagues, you're confident that they are within the 1 mile.
I am under the understanding they
Yeah.
do reside within 1 mile of the district's boundary.
Okay.
Yes.
I'm fine with adding them in, then I'll trust I think that was just an oversight on my part, but
That's why we double check.
Yeah, yeah, I'm glad we asked.
And they're in multiple halls, so I wanted to make sure I
Right.
hadn't misunderstood.
Yeah, got it. I appreciate that. I think, well, that disposes of all the issues, right? And we may be ready for a motion. What additional thoughts
As
do
to
you have?
the last item in your motion that I certainly agreed with you on, I don't believe that this is a matter appropriate for ADR referral, given the number of parties.
Yeah.
It sounds like we're in agreement. So I will make the motion that we grant the hearing requests of Ellis County, the City of Waxahachie, Christopher and Corey Dillo, Kyle and Megan Dillo, Travis Dillo, Vicky Dillo, Tabitha Faulkner, Tracy Evett, Gary Reed, Stacy Reed, William Rogers, Tabitha Tricomi Rogers, Kenneth Hall Sr., Ann Hall, Sharon Plunkett, Mike Foran, Daniel Friss, Stephanie Friss, Randy Rogers, Casey Rogers, Brandon and Paula Lee, John Boswell, Monica Hall, Kenneth Plunkett, William Kuntz, and Christy Picos, and that we refer the matter to SOA for a contested case hearing on the petition.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 3 is the consideration of a petition filed by Finch FP Limited for the creation of Lakeview Municipal Utility District Number 3 of Ellis County. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have been signed in will be noted for the record.
So on this petition, I would grant the requests of the county, the city, Richard and Robin Carroll, and Carlton and Jackie Milam. This proposed MUD also lies within the county and the ETJ of Waxahachie. Both the county and city filed timely requests citing issues germane to our consideration of the petition and which are within their legal authority. Richard and Robin Carroll's timely request cites a concern about rising water levels from the lake behind their house, and in my mind, that implicates drainage issues, and so therefore implicates Section 54.021B3. Given that their property is approximately a tenth of a mile from the district boundary, I would consider them to be affected persons. Carlton and Jackie Milam's timely requests express concerns about runoff and flooding, which again implicate drainage. Their property is approximately 0.3 of a mile from the proposed boundary, so I would likewise consider them to be affected persons. And I would deny the remaining requests, again, for the reasons that I outlined in the discussion on item 1. That was a shorter list of names. Maybe I did a little bit better on that one. Commissioner Lindley, what do you think?
I'm in agreement with the parties that you listed. Yes.
Commissioner
Likewise.
Janeka. All right, I believe we're ready for a motion.
I would move that we grant the hearing requests of Ellis County and City of Waxahachie, Carlton and Jackie Milam, and Richard and Robin Carroll, that we refer the matter to SOA for a contested case hearing on the petition, and that we go ahead and refer this matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application by Glado Metals Recycling LLC for the renewal and amendment of IHW permit number 50204. The parties have been notified that the commission will not take oral argument but may ask questions, and those that have signed in will be noted for the record.
So colleagues, this is a HB 801 hearing request, so we follow the familiar two-part analysis. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And assuming at least one requester meets the requirement, we then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. Associations can have standing if they name at least one member who would have standing in his or her own right and raise issues that are both germane to the organization's purpose and relevant to this application. And in this case, we just have a single hearing request. It's by an association, the Citizens for Clean Air and Clean Water. The executive director and OPIC agree that the association is entitled to a hearing, and I agree with them. I think they're right. The association raises issues that are relevant and material to the application and that are germane to the organization's purpose, and it has done so in timely comments and a timely hearing request. John Kuches is the association member whose residence and business properties are located closest to the facility, and that's slightly less than a mile to the facility boundary and perhaps slightly more than a mile to the regulated activity. And whether it's slightly more or less really doesn't make a difference in my mind on this case. What is important is that the association asserts that Mr. Kuches has both economic and health interests that are foreseeably affected by the application. That certainly appears to be the case, and given his proximity to the facility, I believe that those are personal justiciable issues, so I would grant the request. And before I turn to the issues, let me pause and gather your thoughts. Commissioner Lindley.
I'm in agreement. I think it's appropriate to grant the request.
Likewise.
I see nods. Thank you. All right, turning to the issues, I believe the association has asserted several referable issues, and I've identified 8 or organized them into 8 separate issues as follows. Whether the compliance history raises issues regarding the applicant's ability to comply with the permit or require additional conditions, whether the draft permit is adequate to protect the health and safety of the association members near the facility, whether the application and draft permit satisfy the state's adopted by reference requirements for hazardous waste imported from outside the United States, whether the application and draft permit satisfy the requirements to address existing on-site contamination, whether the application and draft permit satisfy the requirements for closure and post-closure of Unit NOR 10, whether the draft permit contains adequate conditions to protect against adverse impacts to environmental receptors, groundwater, and surface water near the facility, whether the application adequately supports the draft permit's removal of air emissions requirements and standards previously required under IHW permit number 50204, and finally, whether the applicant complied with the applicable notice requirements. And how did those crosswalk with your issues?
You listed off all the issues I would refer.
Thank you, Commissioner Janeka.
Encompassed all of mine perfectly.
Okay. There's also a request for reconsideration that, in my review, didn't raise any new issues for us to consider, so I would deny that. And with respect to a hearing duration, we're not bound to 180 days in this on this item, but I do think that's probably an appropriate duration for the hearing. And
I agree.
I think that about covers it. So I'll entertain any additional ideas or a motion.
I don't have any other ideas.
All right.
Let me venture forth with that motion. I will move that we grant Citizens for Clean Air and Clean Water's hearing request, that we deny the request for reconsideration, that we refer the application to the State Office of Administrative Hearings for a contested case hearing on the following issues. Issue 1, whether the compliance history raises issues regarding GMR's ability to comply with the material terms of the draft permit or requires additional permit conditions. Issue 2, whether the draft permit contains adequate conditions to protect the health and safety of the Citizens for Clean Air and Clean Water's members residing and working near the facility. Issue 3, whether the application and draft permit satisfy the state's adopted by reference requirements for receipt of hazardous waste imported from outside of the United States. Issue 4, whether the application and draft permit satisfy the requirements to identify, report, delineate, and remediate existing on-site contamination. Issue 5, whether the application and draft permit satisfy the requirements for closure and post-closure care of Unit NOR 10. Issue 6, whether the draft permit contains adequate conditions for managing the facility's waste streams to protect against adverse effects to environmental receptors and groundwater and surface water near the facility. Issue 7, whether the application adequately supports the draft permit's removal of air emissions requirements and standards previously required under IHW permit number 50204. And Issue 8, whether the applicant substantially complied with all applicable public notice requirements. And finally, I move that we establish a maximum hearing duration of 180 days from the first date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call item 5.
Item 5 is the application by Port Arthur LNG LLC for new air quality permit number 158420, prevention of significant deterioration permit number PSD TX 1572, and greenhouse gas PSD permit number GHG PSD TX 198. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you, Ms. Smith. Colleagues, this is another House Bill 801 hearing request. So first we consider whether the requester has met the procedural and substantive requirements to be entitled to a contested case. And if so, we then consider which issues are appropriate to refer for hearing. And on this item, we have a single requester, and again, it's an association. In this case, the Port Arthur Community Action Network, or PACON. PACON raises issues that are relevant and material to the application and that are germane to the organization's purpose, and it has done so in timely comments and a timely hearing request. So whether PACON has a right to a hearing turns on whether it has identified a member who has standing in his own right. And here, PACON has identified one member, John Beard. Mr. Beard resides just under 4 miles from the proposed facility, and that's beyond the point where the commission would normally identify a personal justiciable issue. But there are a couple of factors in this case that give me some pause. First, this authorization is not trivial. The character and quantity of emissions could warrant consideration of probably should warrant consideration of a larger radius than we ordinarily would look at. But more importantly, PACON has identified Mr. Beard's recreational interests in portions of Pleasure Island that are within 900 feet of the proposed plant. And a right, just a mere right to recreate in a particular area is clearly an interest that's common to the general public. And exercising that right doesn't somehow turn it into a personal justiciable issue. However, where an actual recreational use is sufficiently intense and sustained, the commission has in the past recognized that interest as a personal justiciable interest. And colleagues, in my mind, this could go either way. And although PACON has averred that Mr. Beard's recreational interests are personally justiciable, I think we're just short on facts to know one way or another, whether it's personal or an interest common to the general public. So I want to pause and get your reading of the issue before we figure out what to do with that. Commissioner Lindley.
I think you stated everything very well, so I won't pile on much. Yeah, I've struggled with this one. And where I've come down is, I, like you, there wasn't enough, let me just say it this way, I'll be very blunt. There wasn't enough in PACON's filing for me to get there to even grant a hearing to determine if he's affected. I think they were very, very close in their arguments, but for me, I feel like the opportunity was provided for those arguments to be made, and it just didn't get there for me. And so I think the question we have before us is, do we refer Mr. Beard and the association for an effectiveness determination? Do we grant the permit? Do we, deny it? And where I've come down just from reading the filings a couple times now is denying a hearing request. That's just my opinion. I tried real hard. I read it a couple times, and I think it's a very close call, but I feel like the opportunity was there for there to be more in the filing, for me to be able to be comfortable granting a hearing, and but there just wasn't the words in the filing for me to get there. So that's where I am on it.
Appreciate that. Thank you, Commissioner Lindley. Commissioner Janeka.
It sounds like I'm going to be a bit of a tiebreaker, and I'll just come out of the gate and clear it. I think I'm in line with your thinking, Chairman, and certainly with the aspect of the size of the emissions at hand here, the prospect of this, some of the arguments this community the association has articulated about the community, and I think those are strong. There's a strong likelihood that the process will be really highly scrutinized for this permit, regardless, and taking the extra time, the extra step to allow the determination to be made on Mr. Beard's effectiveness. It, in my mind, was almost my certainty was undermined a bit in some of the additional clarifications that we received from the parties. His role with the organization that operates around and supports Pleasure Island, in my mind, added on additional to those articulated recreational interests, an easy. Well, there's a quasi-professional work need that now appears to have ended, but I don't think that would necessarily materially change the manner of Mr. Beard's activities or exposure on this from that vector that he's articulated. So I agree that having the additional step and certainly with the breadth of issues that are raised, I think the best decision for our agency is served with having the SOA judge weigh in.
Thank you, Commissioner Janeka. And it's a tight call for me, but I think I do come down with you, Commissioner Janeka. So it sounds like we're going to have a very rare split vote on this, which is fine. That happens from time to time. I do think that that for efficiency and consistent with our normal practice, we're going to have to identify issues to be referred in the event that SOA does find Pecan to be an affected person. And so I would organize those issues as follows, and there's 10 of them. Whether the draft permit will be protective of health and safety of the requesters, whether the proposed emissions will cause an exceedance of the NACs, whether the proposed emissions will create a nuisance, whether the air quality analysis is consistent with TCEQ's rules and guidance, whether wildlife and the environment in the area will be protected, whether the proposed controls constitute best available control technology, whether the emission rates were accurately calculated using correct methods, whether the quantity of emissions from the project will exceed allowable prevention of significant deterioration increments, and finally, number 9, whether there are adequate monitoring and reporting requirements, and finally, number 10, whether cumulative impacts were evaluated appropriately under TCEQ's rules. And Commissioner Janeka, how does that sound?
Those captured all the issues that I found the party raised.
Okay. In my mind, you don't need to have an opinion on this, but would you like to weigh in?
You're correct.
Okay.
Thank you, though.
All right. Hopefully, well, if SOA were to determine that Pecan is not an affected person, I would hope that they could return that finding to us pretty quickly. In case they do, I think we ought to set a hearing duration of 180 days, if that sounds all right to you.
I would agree.
All right. I think it falls to you, Commissioner Janeka, to read a motion.
I move that we, I make the motion that the chief clerk shall refer the hearing request filed by Port Arthur Community Action Network to SOA to determine whether its member, John Beard, is affected. Should SOA determine that Port Arthur Community Action Network has demonstrated effectiveness, then the following issues are referred to SOA for a contested case hearing. Whether the proposed permit will be protective of the health and safety of the requester, whether the proposed emissions will cause or contribute to exceedances of the national ambient air quality standards, whether the proposed emissions will cause nuisance conditions violating 30 Texas Administrative Code, Section 101.4, whether the air quality analysis complies with TCEQ's rules and guidance, whether the proposed plant will be protective of welfare, including wildlife and the environment in the surrounding area, whether the controls proposed in the draft permit constitute best available control technology, whether the emissions rates in the draft permit are accurately calculated using the appropriate methodology, whether the quantity of emissions from the project will exceed allowable prevention of significant deterioration increments, whether the proposed permit contains adequate monitoring and reporting requirements, and whether cumulative impacts were appropriately evaluated for the project pursuant to applicable TCEQ rules and guidance. And finally, I move that we set the duration of the hearing at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
Thank you, Commissioner. I will second your motion and call the vote. The motion has been made and seconded. All those in favor say aye.
Aye.
All those opposed say nay.
Nay?
We have one nay. The motion carries. Ms. Smith, please call the next item.
Item number 6 is the application by Stella Jones Corporation for air quality permit number 8286. The parties have been notified that the commissioners will not take oral argument, but may ask questions. Those who have signed in will be noted for the record.
So colleagues, we have a single requester on this item, Ms. Jordan, and because of the type and relatively modest amount of emissions from this facility, and that Ms. Jordan lives more than 2 miles away, I agree with the executive director and the Office of Public Interest Counsel that Ms. Jordan is not an affected person. Her interests are common to the general public. Commissioner Lindley?
I'm in agreement.
Commissioner Janeka?
Likewise.
I'll entertain a motion.
I would move that we deny the hearing request filed by Betty C. Jordan, that we issue air quality permit number 8286 to Stella Jones Corporation as recommended by the executive director, and that we adopt the executive director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 7 is the consideration and hearing on a resolution from Williamson County Water Control and Improvement District Number 2, requesting the approval of additional wastewater and drainage powers. Williamson County Water Control and Improvement District Number 2 has requested the approval of additional wastewater and drainage powers and should present the item, followed by the interested persons. Currently, no one is signed in, the ED and OPIC. The Office of General Counsel recommends the standard 5 minutes for oral presentations.
Thank you, Ms. Smith. And I understand we have Mr. Hamala on the line for the petitioner. I hope I've pronounced your name correctly. Are you there, sir?
Yes, sir, and you pronounced my name perfectly. My name is Richard Hamala, and I'm the general counsel for the district, and I worked with the engineers, Jones, Heroy, and Associates to prepare and submit the application. Briefly, this district was created in 2003 by the Williamson County Commissioners Court. At the time of creation, it was planned to be a large lot subdivision with on-site septic systems, and so the commission creation with water powers was sufficient. Time has passed, 18 years, and the plan for development has changed to, take advantage of regional wastewater opportunities, wastewater solution opportunities, and we've come to the commission to, under the provisions of Chapter 51, to get the wastewater and drainage powers so that this district can fund participation in regional wastewater solutions. And so that's why we're here. I don't have much further to say, but I'd be happy to answer any questions of the commissioners.
Great. Thank you, Mr. Hamala. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, but thank you so much for the additional, or the very simple explanation.
All right, let's hear next from the executive director's staff. And you might double check your mic just to make sure you're unmuted.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Bobby Salihi. I'm an attorney with the Environmental Law Division representing the Executive Director. With me today is Jamie Ely with the District Section. The Executive Director received a resolution from Williamson County Water Control and Improvement District Number 2 requesting approval for additional powers to dispose of waste and control stormwater pursuant to Texas Water Code Section 51.331 and 30 Texas Administrative Code Section 293.15. We have reviewed the resolution and concluded that all applicable requirements have been met. The ED recommends granting the resolution for additional powers. We are available for any questions you may have. Thank you.
Thank you, Mr. Slahy. I have none. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Janeka?
None, thank you.
All right, we just heard that no one has signed in to speak on this item, so let's hear next from Mr. McWhorter.
Wolfake recommends granting the application of Williamson County Water Control and Improvement District Number 2 for additional powers to provide drainage services within the district as presented by the Executive Director and the applicant.
Thank you, Mr. McWhorter. Colleagues, I believe that the district's request as well as the proposed order satisfy the applicable requirements and that the public notice and the city filing requirements have also been met. The benefits of this request are pretty evident, and it appears to be without controversy. I do have a pair of corrections to the order, however, and I'm going to propose that we insert some language that appears to just have been inadvertently left out in two places. The first is in the third paragraph, second to the last sentence of the order, I would add the words, "the ability," and that's in reference to treating waste and controlling stormwater. And in the very last sentence of the order, I would add wastewater services alongside drainage services. And what I thought I'd do is just put that into context by actually reading a motion, and then we can discuss it on the other side. So I move that we approve the request of Williamson County Water Control and Improvement District Number 2 for additional powers to provide wastewater and drainage services within the district, and that we issue the Executive Director's proposed order with the following modifications. 1, approve the request of Williamson County Water Control and Improvement District Number 2 for additional powers to provide wastewater and drainage services within the district, and 2, issue the Executive Director's proposed order with the following modifications. Revise, and I just realized I'm repeating myself because I did a poor editing job. My apologies, but better to be redundant than to omit
That's
something.
right. That's right.
Ms. Smith, am I okay just to continue reading this motion, or should I start from the top?
I think it's fine. We'll consider the first 1 and 2 as not part of the motion, and the second 1 and 2 as the motion.
Fair enough.
Okay.
I was doing some cutting and pasting of my notes this morning, and was not didn't have adequate quality control on it. Tell you what, let me start this from the top.
Okay.
Let me start from the top. I'll feel better that way. That way we can edit all this stuff out later. No, we actually don't do that. All right. I got it. From the top, I move that this is, I'm out of practice. I don't get to read
hear ya.
motions very often. I have a new appreciation for what you guys bring to the bring to the dais every agenda. Okay, here we go. I move that we approve the request of Williamson County Waste Control and Improvement District Number 2 for additional powers to provide wastewater and drainage services within the district, and 2, issue the Executive Director's proposed order with the following modifications. Revise the second to last sentence of the third paragraph to state, quote, "The Commission finds that expanding the powers of the district to include wastewater and drainage services will give it the ability to treat waste and control stormwater to prevent erosion and flooding." And the second modification, revise the last sentence of the order to state, quote, "Now, therefore, be it ordered by the Texas Commission on Environmental Quality that the application of Williamson County Water Control and Improvement District Number 2 for additional powers to provide wastewater and drainage services within the district is approved pursuant to Texas Water Code Section 51.331 through 51.332 and 30 Texas Administrative Code, Section 293.15, end quote. And that also ends the motion. All right.
I think when you were rereading your first point, you called the entity Williamson County Waste Control and Improvement District Number 2.
We've
But I'm
gone.
assuming that you meant Williamson County Water Control and
Okay.
Improvement District.
All
Number
right,
2.
we can treat that as a friendly amendment.
I support that friendly amendment
Okay.
and second that motion.
All right. I've gone off the rails. I'm glad I've got you guys here to help me out.
I'm glad someone else has moments.
You went and caught two really good inadvertent admissions, and then in trying to,
I was trying to be efficient and move us along here, you guys.
it all balances out.
Okay, I think we have a motion, yes?
I believe
And
so.
And
do
a
we have a
And I
second?
second, yes, I
All
second.
right, here we go. Now I'm back in my comfort zone. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye, the motion carries. Ms. Smith, please call the next item.
Item number 8 is the annual review of financial assurance mechanisms and cost estimates for radioactive material license number R04100 held by Waste Control Specialists, LLC. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Vishali Tendolkar with the Radioactive Materials Division. With me is Ashley Forbes with the Radioactive Materials Division, Amy Robinson with the Environmental Law Division, and Mark Stobner with the Financial Administration Division. In compliance with 30 Texas Administrative Code Section 336.736C, Waste Control Specialists' financial assurance mechanisms and cost estimates are reviewed to assure that sufficient funds are available for completion of the low-level radioactive waste disposal site closure plan. Included in your backup materials is the radioactive materials license financial assurance for waste control specialists for your review and approval. Thank you for your consideration. We are available to answer any questions.
Thank you, Ms. Tendolkar. I have no questions. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
No questions. Thanks for the presentation.
Ms. Smith, has anyone signed in to speak on this item?
No one's registered on this one.
Thank you. And Mr. McWhirter, what do you think?
OPIC has no objection to the findings of the review of the licensee's financial assurance mechanisms and cost estimates as presented by the Executive Director.
Thank you. And Commissioner Janeka, in deference to your relative depth in this area, I thought I might invite your comments first.
I appreciate it, and I do note that the last time that there would have been required real substantive change to this item would be the first amendment that I joined this agency originally closer to 7 years ago now, and so I am painfully familiar with the ins and outs of this topic, and I think that it's a useful and necessary step to go to the public and let them know, yes, the amounts of money are still sufficient for the potential needs for this waste site. There will be an inflation adjustment this year, but until and as the company may propose or expand operations, the big substantive change that we made at that time, back with the 26th Amendment of the site's license, was merely reducing down from the total potential amount of what the site could be built to, and requiring a financial assurance for closure, decommissioning of all of those facilities. We stepped back from a very conservative posture that reflected that standard down to a more consistent with other waste facilities across our state and across the rest of the country. We only require coverage for the facilities that have been built. So it does fall to the Radioactive Materials Division to watch as amendments to the license are made or as operations continue over the years. As the number may creep up for a material reason, they would want to adjust this number. I'm not aware of any big major expansions or construction that's taking place relative to the licenses at hand here. So I'm closely watching this one, but I do appreciate y'all's indulgence in letting me talk a little bit about something that I so much rarely get to dive into.
We appreciate your insights. Thank you for that.
And I will just wrap all that up by making a motion that we approve the waste control specialist's financial assurance mechanisms and cost estimates as recommended by the executive director.
I
Thank you.
second. Oh, sorry.
All
I
right.
second.
I don't think I have anything to add to that. So the motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call item 9.
Item 9 is the consideration and approval of the TCEQ Chief Auditor's Office Fiscal Year 2022 Annual Risk Assessment and Audit Plan. The Chief Auditor is here to present the item.
Good morning, Mr. Hardison.
Good morning, Chairman Nehrman, Commissioner Lindley, Commissioner Janeka, Public Interest Counsel, General Counsel. For the record, my name is Mike Hardison, and I'm the Chief Auditor of the TCEQ. I'm here today to present and seek approval of the annual risk assessment and fiscal year 2022 audit plan prepared by my office. Texas Government Code 2102 requires that the Chief Auditor of the agency prepare a risk-based audit plan each year and that the plan be approved by the agency's governing board. My staff and I have prepared a risk assessment of TCEQ programs, processes, and information technology systems in order to develop our fiscal year 2022 audit plan. And we believe that the projects proposed to be completed in the upcoming fiscal year address the high-risk areas identified during that risk assessment. At this time, I'd request your approval of our audit plan and welcome any questions you may have for me.
Thank you, Mr. Hardison. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka.
No questions. Thank you so much for your work.
Ms. Smith, do we have anyone signed in?
No one signed in on this one.
Thank you. And Mr. McWhirter, what are your thoughts?
I don't have any questions. I support the plan and recommendations as presented by Mr. Hardison.
Thank you. And thank you again, Mr. Hardison. I really appreciate the great work that you and your team do. Colleagues, I've reviewed this item. I've been briefed on the plan. I think I'm ready to approve it.
As am I, and I have a motion if we're ready. I would move that we approve the fiscal year 2022 annual risk assessment and audit plan as recommended by the Chief Auditor.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
The next item is old business item number 1. The Executive Director's staff is here to present.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. Can you hear me?
Loud and clear. Thank you.
Thank you. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Beckins of the Litigation Division representing the Executive Director. Pending before you is old business item number 1. The total assessed administrative penalties are $13,164 with $2,632 deferred and $10,532 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. Colleagues, any questions? Seeing none.
No questions.
Has anyone signed in to speak on this item?
No one has signed in.
Thank you. Mr. McWhirter, do you have any thoughts on this item?
OPIC has reviewed it, and we support approval of the order as presented by the Executive Director.
Thank you. It's been several weeks now. Commissioner Janeka, I recall that you may have flagged this one, and I appreciate having the extra time to look at it and wanted to get your thoughts and recommendations.
I was pleased to receive a little additional analysis of the item from our staff, and I think that was a useful exercise. I think one that hopefully will give the public some additional assurances that we are taking full opportunity to review the matters that come before us, while also trying to respect the very personal and detailed information that may be personal information dealing with Texans. So we want to scrutinize that in as thoughtful a manner without necessarily revealing the private information of Texans unnecessarily. So I've had some of my concerns better answered on this matter. I think that it does appear to be a case where it would be appropriate for our commission to utilize the additional authority available to us to offer more discretion on further reducing that penalty due to the factors of the inability to pay. I recognize that's also a very seldom used authority, so I wanted to just defer and get each of your thoughts on it.
Thank you, Commissioner Lindley.
Yeah, this one was tough, and I was very grateful for the added detailed information we got. I would be comfortable utilizing that additional authority. I don't necessarily have a recommendation of what that should look like, but I think I could get there on us deciding something a little different than what the executive director recommended. And to be fair to the executive director, I think they were as fair as they could be in this situation, and they utilized all the tools they had as well to get to what was in the agreed order.
Yeah, thank you for that, Commissioner Lindley. The ED staff did everything that they could, and I certainly appreciate that. This, in my reading, this is a case of extraordinary personal hardship, and if we're ever going to use the Commission's discretion to depart from the penalty policy, I think this is a case. This is the case to do it. So I am in favor of remanding this for a different result. But I don't have a motion prepared or particular instructions that go along with that. And
do we remand it, or do we just set the?
Ms. Smith, what's your recommendation?
I don't know.
You can remand with direction to the ED to reduce the penalty to whatever amount you agree upon under your other factors as justice may require.
And I think the particulars of this matter, or the executive director have recommended a reduction to the full extent that they're able to, and that's a minimum of $1,200. It's so we could remand with instructions to the executive director to pursue an agreed order, further reducing that amount to reflect our discretion authority.
That's my understanding.
And so I think we just need to pick a number, right?
Mm-hmm.
And to clarify, the additional information that was received was confidential and personal information regarding the respondent's financial inability to pay.
Thank you. I also do want to recognize that these are administrative documents and agreements that time is often of the essence as much as dollar amounts are, so that this may be an olive branch that inadvertently comes in far heavier as a gift, so that this may not be a welcome or helpful relief in terms of what was a settled matter in the eyes of this party with the executive director. So I appreciate that we've had additional time, and I don't think that I've heard any concerns from that direction of us taking further action on it. Not to waffle on it, but I did want to recognize that reality of our process. Oftentimes people are far happier just to be out of the enforcement wing of our agency and done with the paperwork, which I appreciate. There's a deterrence effect in our bureaucratic force that we carry.
I have a proposal that we remand it with instructions to resolve it on an agreed order for sums already paid.
Is that a motion? Do I second that? I'm comfortable with that.
Let me phrase it as a motion. I move that we remand this matter to the executive director to include an adjustment under other factors as justice may require to reduce the penalty to sums already paid.
I would second that.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you, colleagues. Thank you, Ms. Smith. Ms. Smith, please call the next items.
That takes us to our new business enforcement docket, items 10 through 26. The executive director's staff is here to present these matters.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Susan Jablonski, also of the Enforcement Division, and Charmaine Backins of the Litigation Division, representing the Executive Director. Pending before you are items 10 through 26. The total assessed administrative penalties are $286,043, with $56,607 deferred, $20,192 applied towards supplemental environmental projects, and $219,244 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
Likewise, no, thank you.
And Ms. Smith, is anyone signed in to speak?
On items 10, 13, 15, and 16, we have individuals who have signed in but indicated that they're simply there and available if the commission has questions, and their presence will be noted for the record.
Thank you. Mr. McWhirter, what are your thoughts?
My office reviewed the backup material for these items, and we support the executive director's recommendations for approval.
Thank you. I agree. I've reviewed these items and think it's appropriate for us to move forward. Commissioner Lindley, what do you think?
I'm in agreement.
Commissioner Janeka?
I'm also in agreement, and I will move that we adopt items 10 through 26 as recommended today by the executive director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 27 is the consideration of the monthly enforcement report, and the executive director's staff is here to present.
Good morning again.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Susan Jablonski of the Enforcement Division and Charmaine Backins of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2021 through June. There were 764 effective administrative orders issued, and of those, 108 contained supplemental environmental projects. These orders assessed a total of $8,255,223 in penalties, with a payable amount of $5,178,930. $1,758,039 are to be paid towards supplemental environmental projects. 13,016 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,576 enforcement action referrals have been received. There are 1,743 pending administrative orders, with 266 cases that are on the backlog. 203 cases are pending at the Attorney General's Office for Representation in District Court, and 14 judgments have been issued. 2012 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2019, 20, and 21. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Thank you for the report.
And we have no one signed in to speak on this item.
That's correct.
Mr. McWhirter, what do you think?
I don't have any questions. I appreciate the report.
Likewise, thank you, Ms. Cordell, to you and your team for the report. No action is necessary on this item. I'm going to have Ms. Smith call the next item, item 28, but I do want to note that this item will be translated, and the commission is not accustomed to translations during agenda meetings, so we're going to learn a new skill, or begin to learn a new skill. And I think one of the keys is to speak slowly and provide breaks, and make life as easy as we can on Ms. DeMasi, who's going to be facilitating the translation. She has the disadvantage of not being with us to send us body language or eye contact, but I'll trust her to interrupt us and slow us down if we're making her job difficult.
Chairman, you brought up breaks. I might ask for a quick 2-minute break if you don't mind before we
dive
into this one real quick.
Why don't we do that now? The time's 10:34 a.m. Why don't we take a proper break and return at 10:40? Okay. All right. With that, the time is 10:34, and we are in recess. Colleagues, the time is 10:40 a.m. and we are back after a short recess. Ms. Smith, I'm going to have you call item 28 in just a moment. Before we do that, I had noted that we're going to begin learning the skill of using a translator in our agenda meetings, and I wanted to give Ms. DeMasi an opportunity to provide any additional advice or instructions that I missed. And in addition to that, Ms. DeMasi, if you would repeat the instructions for folks who may want to participate or comment, the instructions for dialing into your line for translations, I think that would be helpful as well. So I'll stop talking, and Ms. DeMasi, the floor is yours.
Thank you, Mr. Burnson. Las personas que deseen escuchar o participar en la reunión en español pueden llamar al número de teléfono 844-368-7161 e ingresar el código de acceso 904535 y el símbolo de número o símbolo de gato. Repito, las personas que deseen escuchar o participar en esta reunión en español pueden llamar al 844-368-7161 e ingresar el código de acceso 904535 y el símbolo de número o el símbolo de gato. And Mr. Burnison, the person that was going to be speaking in Spanish decided to make her comment in English.
Thank you, Ms. DeMasi.
Yes.
Ms. DeMasi, do you have any additional instructions for the commissioners about how we approach this, or is simply go slowly and pause frequently the best advice?
Yes, please. If you could please just make a pause. The person having the comment will be speaking in English, and we will be on standby should you need us to interpret.
Thank you, Ms. DeMasi. With that, I think we're ready, Ms. Smith, for you to call item 28.
Item 28 is the adoption of new section 39.426 and amendments to sections 39.405, 39.412, 39.418, 39.419, 39.423, 39.503, 39.602, 39.604, and 39.651 of 30 Texas Administrative Code, Chapter 39, regarding public notice, and amendments to sections 55.154, 55.156, and 55.210 of 30 Texas Administrative Code, Chapter 55, requests for reconsideration and contested case hearings, public comment, and corresponding revisions to the state implementation plan. The executive director's staff is here to present this item.
Good morning.
Good morning. Can you hear me?
Yes, thank you.
Okay. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Amy Browning with the Environmental Law Division. With me is Adam Taylor, also with the Environmental Law Division. This adopted rulemaking would add new section 39.426 and amend sections 39.405, 39.412, 39.418, 39.419, 39.423, 39.503, 39.602, 39.604, and 39.651 of 30 Texas Administrative Code, Chapter 39, Public Notice, as well as amendments to Sections 55.154, 55.156, and 55.210 of 30 Texas Administrative Code, Chapter 55, requests for reconsideration and contested case hearings, public comment, and corresponding revisions to the state implementation plan. The adopted rule also withdraws the proposed change to Section 55.209. The proposed revisions regard providing translation and notice in alternative languages for various aspects of the permitting process. The proposed rules were published in the March 26, 2021 issue of the Texas Register. Virtual public hearings were held on April 20th and 22nd, 2021. The public comment period closed on April 26, 2021. The rules team did receive public comments, and based on those comments, the rule team made the following substantive changes. The final rulemaking differs from the proposal in that the final rule specifies that translations of documents may be done using any resource available. The final rule clarifies that alternative language notice for public meetings that is required will be mailed by the Office of the Chief Clerk. When alternative language comments are received on a permit application, the Executive Director will evaluate the need to provide the response to comments, or RTC, in the alternative language. The factors the Executive Director will consider when making this determination are if the comments received were substantive, how many comments in an alternative language are received, if the language in which the comments are received is commonly spoken in the community, if a notice was required to be published in that language, and if an alternative language response is necessary to ensure that the commenter can fully participate in the processes of the Commission related to the application. If the Executive Director determines that a translated RTC is not necessary, then the RTC transmittal must provide information about how to use available resources to translate the RTC. The adopted rules clarify that any responses to reconsideration and hearing requests filed by the Executive Director, OPIC, or the applicant will be provided in the alternative language if a request for reconsideration or hearing is received in an alternative language. The adopted rules removed the requirement for simultaneous interpretation when interpretation is necessary at public meetings or at Commission meetings such as agenda. The adopted rules remove the proposed requirement for translation of an RTC or interpreters at a public meeting at the request of a local legislator. The adopted rules remove the proposed requirement for translation. The adopted rules will provide that most of the new alternative language requirements will apply to permit applications declared administratively complete on or after May 1st, 2022. Additionally, the adopted rules will have an added provision to govern remedies for errors in translation and specify that the English language document controls if there is a discrepancy between the versions. Finally, the adopted rules will not provide additional time for translations of RTCs in response to requests for reconsiderations, requests for hearings, as was proposed. In conclusion, staff respectfully recommends adoption of this rulemaking to chapters 39 and 55. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Ms. Browning. I have none. Commissioner Lindley, any questions?
No questions right now. Thank you.
Commissioner Janeka?
Not at this time. Thanks.
Thank you. We have quite a list of interested persons who have signed in to speak on this item. And Ms. Smith, I think I'll have you read those names as they come up.
The first person on my list is Bridget Murray.
Good morning, Ms. Murray.
Well, good morning, and thank you, commissioners. I am representing a grassroots, community-based organization achieving community tasks successfully. And while we are in agreement that the commission should make some changes and make language justice a priority, we are very concerned with the rules as they currently are written, that it will not meet the needs of those individuals where English is not their primary language. We feel that it is important for clear communication between both the agency, the residents of communities that may be impacted by environmental or toxic exposures, and we only seek to ensure that all parties are fully comprehending the expectations and how to move forward. So we ask that you not approve the rules as they're currently written, and continue to work with those agencies and organizations that have supported and supplied other considerations. Thank you.
Thank you, Ms. Murray.
Next, I have Isabel Segarra Trevino.
Good morning.
Good morning, Chairman, Commissioners, Executive Director, and Public Interest Counsel. My name is Isabel Segarra Trevino, and I serve as an Assistant County Attorney for Harris County, Texas. Before I provide comment, I would like to thank the Commission for bringing this rule proposal forward. Not enough can be said about the state's changing demographics. According to the most recent U.S. Census, Latinos account for over half of the population growth over the past decade in both the United States and Texas. Given these demographics and the state's lengthy legacy of discrimination against Spanish-speaking people, these rule changes are sorely needed. The Harris County Attorney requests that the Commission remand this matter to the ED because there are significant aspects of the rule that require revision. My comment raises 3 points, and these are not the only issues we would like to see addressed. First, the implementation date. Second, the safe harbor provision. And third, translation of the RTC. First, the Commission seeks to apply the new rules to applications declared administratively complete on or after May 1st, 2022. While the county agrees that implementing the rules to administratively complete applications is a good approach, May 1st, 2022 is nearly a year from today. The Commission could implement aspects of the rule in a more timely manner, such as meeting and hearing notice translations and interpretation requirements for the same. Lastly, on this point, the Commission does not state the date by which it proposes to incorporate the rule changes into the state implementation plan. Once incorporated into the SIB, the rule changes would form part of federal permitting requirements. The Office of the Harris County Attorney would like to know the date by which the Commission expects to incorporate this rule into the SIB. Second, the Commission proposes new Section 30 Tag 39.426G1 to provide applicants with a safe harbor provision in case of inaccurate translation by having the English version of a document control. Further, under the rule, only substantive errors would trigger renotice, while others require a showing of willful misconduct. But TCQ does not define or provide examples of instances where a mistake would trigger renotice or those that the Commission would consider willful.
That's 3 minutes.
Thank
Please-
you. Could I wrap up, please?
Please do. Thank you.
Let me jump here. Right, so that puts us in the same place where the Commission started, where these gaps have to be filled by charities and outsiders, and this is what was supposed to be addressed in the informal resolution agreement. The point I'll make very quickly is that the RTC is a vital document. DOJ guidance provides that vital documents are paper or electronic written material that contain information that is critical for accessing a program or activity. The RTC is this type of document. In conjunction with the response to hearing request, as we all know in practice in this field, the RTC gives us the basis of any challenge because it provides the ED's rationale. And so we are left in a situation where an LEP resident could receive a response to a hearing request in, say, Spanish, and the RTC would be in English. The rule does not extend the time by which a hearing request must be filed or a filing in the district court. So this leaves residents in a tricky spot where they may not receive the necessary information to challenge a permit in time. For these reasons, the Harris County Attorney requests that the rule be remanded to change these 3 aspects of the rule because the informal resolution agreement was meant to give the ED clear direction, clear rules as to when they need to translate, when they need to require interpretation. And this will kind of implement some of the same problematic exercises in discretion that the civil rights complaint filed in 2019 was meant to address. Thank you so much.
Thank you. I appreciate your comments. Ms. Smith?
Yvette Arellano.
Good morning.
Good morning. Thank you for the opportunity to speak today with you all and share our concerns. My name is Yvette Arellano, and I'm the director of Fenceline Watch, an environmental justice organization based here in Houston to stop multi-generational harm from extractive industries, oil, gas, and petrochemical. We as an organization request the rule be remanded for the points that have been made prior to my comment from Ms. Segarra, and also because there is confusion within the document itself. 39.46E requires the ED, does not require the ED to translate response to comment for all applications, just to evaluate, but 39.46F does require translation to responses to requests for hearing and requests for reconsideration. Also, this rule is stated to be enacted May of 2022. That is too far past the date from the original civil rights complaint. Additionally, the rule states that there has to be willful misconduct, and as stated, there's no definition over what that means. It also requires a plain language summary that doesn't have health impacts from any of these given permits. All the language states is that the permit has to show how it's beneficial to health and the environment, but doesn't say that it's going to include technical information over short-term, chronic, and acute impacts from these facilities that are requesting these permits. Additionally, the rule states that the director can determine if the alternative language is necessary by the commenter. So it places the burden back onto the public. There is no definition or no guideline over what constitutes as full participation as provided in the rule. Additionally, the TCEQ director can choose to provide alternative language responses to comment, hearing, and reconsideration. And we see this as not being an effective communication with the community that's being affected itself. The rule also omits providing additional time to the ED to provide response to comment. Here at this hearing, you're telling us, go slower, be well-paced. And that's the same kind of consideration that we need to provide translation to our communities, because this civil rights complaint was brought on after a community that has an elementary school with 64% of their student population not knowing English fluently, being affected by a permit application without being able to understand the language. We had children sitting in the room translating as best they could overly technical information for their parents. That is unconscionable, and I request the TCEQ to do better. Thank you for your time.
Thank you. Appreciate your comments. Ms. Smith?
Linda Rodriguez.
Good morning.
Hello, can you hear me?
Yes, thank you.
Hi, thank you. My name is Linda. Thank you for giving me the time to address this alternative language requirements, as they have been a historical barrier to public input in the air, water, and waste process. I represent Greenpeace USA, and I am here because my community, my friends, are affected by language barriers. I would like to share from my personal experience that it is very difficult to translate for a parent, family, and friend without the adequate support or knowledge. My first experience as an unskilled translator was when I was 12 years old. I translated to a language that I was just learning into a language that I was losing every single day. That left the people that were listening unprepared and confused. So I would ask to please not burden our diverse community like my parents and I were burdened in the past. This public notice allows the public to become aware of permitting actions and gives the communities the opportunity to be involved and assess how issues will affect the Latino community, so we may affect enhanced permit terms requisite for the protection of their health and their communities. Although the proposed rule takes some valuable steps toward increasing participation, the final rule put forth by TCEQ will still maintains barriers that negatively impact alternative language Texans and does not provide full equitable access to the public input process. So this rule must address using any resource that's not ensure accurate translation, and it places the burden on the public. I would like for this proposed rule allows for the use of any resource available to translate documents. This opens door for non-professional translation, either through uncertified, unqualified human translation, or the use of unreliable software-based translation programs that potentially omit, misrepresent, or provide erroneous information to limited English proficient alternative language Texans dependent on translated materials. Thank you again for your time.
Thank you.
Erondi Trevino.
Good morning.
Hi, good morning. Thank you for the opportunity to share my comments with you today. My name is Erondi Trevino, and I am the Texas Field Organizer for Mom's Clean Air Force, living in Houston, Texas. We fight for justice in every breath, recognizing the importance of equitable solutions in addressing air pollution and climate change. Today, I urge you to adopt effective revisions for providing translation and notice in alternative languages for various aspects of the permitting process. The tragic reality is that air pollution and its effects are not distributed evenly. Latinos in the U.S. are 3 times more likely to be negatively affected by air pollution because of where they live and work. 68% of Latinos live in areas that do not meet federal air quality standards, compared to 58% of whites. The disturbing fact is that Latino children are 60% more at risk than their white counterparts of having asthma attacks caused by air pollution. And Latinos have a 3% higher cancer risk above the federal standards due to toxic pollution exposure. Children who live within 2 miles of the Houston Ship Channel, as my family and I once did, are 56% more likely to develop leukemia than children living 10 miles away. Existing pollution problems in communities of color and low-income communities exacerbate inequities and put families at increased risk of serious health issues. All Texas should have access to important documents and be able to participate in decisions that impact their lives. Giving the Latino communities increased risks, it is the utmost importance that they are effectively included in all conversations dealing with decisions that affect their health, especially when public hearings occur in predominantly Spanish-speaking areas. Throughout the Houston area, communities such as predominantly Spanish-speaking Manchester and Galena Park continue to experience higher levels of air pollution than white communities. Despite this, they are functionally excluded from the conversation because notices about permits, hearings, and meetings and proposed changes to environmental regulations are nearly exclusively in English. In Galena Park, which is almost 80% Hispanic, there is no safety information about chemical releases available online in Spanish. TCEQ should facilitate full participation despite language barriers, because all Texans deserve to be protected from air pollution regardless of their language abilities. Not only that, but the information shared is often very complex and goes far beyond the translation abilities of children or conversational English abilities of many Latinos. Because of this, I urge you to, again, adopt effective revisions for providing translation and notices in alternative languages for various aspects of the permitting process so that we may get closer to achieving equal protection of all Texans. Thank you for your time.
Thank you. We appreciate your comments. Ms. Smith.
Stephanie Thomas.
Good morning.
Good morning. Can you all hear me?
Yes, loud and clear.
Wonderful. Great. Good morning, everyone. My name is Stephanie Thomas, and I'm the Houston area organizer with Public Citizen, a nonprofit public interest organization. And today, I want to share with you that while this rulemaking is an important first step, I believe that there's many concerning things in this final rule. Some of the previous speakers have spoken about, and one of those that I want to talk about is the issue of translation using any available resource. I don't know how familiar you are with Google Translate, because it is something that is very accessible. Yet, the translation that it provides is not always high quality. I remember translating a document using it for an event once and sharing it with a Spanish-speaking colleague who said, "Oh, this is not right. This is all wrong." So the purpose is to adequately provide information to impacted communities that have a right to know what's happening in their neighborhoods, down the street, across from their schools. And how the rulemaking stands right now does not adequately provide communities with that information, and leaves open the possibility that communities will be receiving incorrect information or poorly translated documents that just provide confusion. So with that, I encourage TCEQ to look again and reconsider some of these proposed changes or some of the changes made in the final rulemaking. Thank you.
Thank you. Ms. Smith?
Shiv Shrivastava.
Good morning.
Good morning. My name is Shiv Shrivastava. I'm with Fenceline Watch, a community-based environmental justice organization based in Houston, Texas. I would like to begin by noting many interested community members are unable to be here today that would like to participate in the process and provide comment, however, are unable due to this meeting being held during the week, during work hours. I'd like to thank the TCEQ for taking steps to provide greater access to the over 10 million Texans who speak a language other than English and 3 million limited English proficient Texans. However, greater access and equitable access are not the same. We request the rule before the Commission to be remanded as the rule before you falls short in providing equal access to non-English speaking Texans. Specifically, the rule allows for the use of any resource available to translate documents. This opens the door for non-professional translation, either through uncertified, unqualified human translation, or the use of unreliable translation-based programs that potentially omit, misrepresent, or provide erroneous information to Texans who are reliant on translated material. The rule establishes that in the case of any discrepancy between English and non-English versions of a document that the English document controls, meaning that errors or erroneous information is allowed in translated documents, and English documents are still considered dominant. If the executive director determines an alternative language response is not required, TCEQ will send a response to an alternative language comment with information about how a person may use available resources to translate response. Responding to an alternative language comment with instructions on how to translate oneself is deficient in providing equitable access. An individual that provides comment in an alternative language should not be expected to read, understand, and act upon information provided in English, nor should the responsibility of TCEQ document translation fall upon the public. Additionally, the rule is ambiguous or opaque in the terms of substantive errors, willful misconduct, minor error, and full participation. These are terms that are used that are ill-defined, not defined. No example or guidelines are given. Additionally, the rule states that the director can choose to provide response to comment in an alternative language based on the number of comments received in an alternative language. But the specific number of alternative language comments necessary to trigger this provision is not stated in the rule. Moreover, the adopted rule omits providing additional time to the executive director to provide a response to comment, request for reconsideration, or request for hearing, to provide response in the language received. That leaves non-English speaking communities once again at a disadvantage in relation to English speaking communities. We at Trendline Watch would like to provide ourselves to the TCEQ as a resource to help provide more equitable access so our communities have equal opportunity to advocate on behalf of our land, air, and water. I appreciate the Commission's time. Thank you.
Thank you. We appreciate your comments. Ms. Smith?
Carmen Cabeza.
Good morning.
Good morning. Can you hear me?
Yes, thank you.
Thank you for allowing me to speak. My name is Carmen Cabeza, and I'm here representing the Coalition for Environment, Equity, and Resilience. CERS is a 20A organization coalition that advocates to bring awareness between the pollution, the place you live, and how that impacts our health. I'm here to request to make language justice a priority. I work as a climate justice organizer, and we help residents see the connections between pollution, climate change, and how that affects our health. It is very difficult to convey the information on how chemicals or pollutants affect our health, and we need to do that in a way that makes sense to residents. TCEQ should make sure everyone understands how it's being affected. When I first started working in the community and I tried to tell residents about the air pollution, it was very difficult to convey that. And one resident told me, Carmen, now I know what you mean about that smell that I've been smelling for years in my community. It's very difficult to convey that in another language. And that placed the burden on us to try to translate whatever you have in your website or whatever you have in your report. There is no guidelines of how to provide translation on health impacts. Information is too technical. That placed the burden in organizations like us to provide translations to residents affected by this. So I'm here to ask you not to approve the rule as is written. And I want you to really place community first, community that they don't speak English, community that they need to understand how they're being affected. I'm here to urge you to put these residents up front and have language justice as a priority. Thank you so much for your time.
Thank you for your comments. Ms. Smith.
Mariana del Valle Prieto Cervantes.
Good morning.
Hi, hello. Can you hear me?
Yes, thank you.
Awesome. Thank you. Good morning, everyone, and thank you all for letting me speak today. My name is Mariana del Valle Prieto Cervantes. I am an advocate with Teen Latinos, a national nonprofit organization who represents an active comunidad of thousands of Latino, Latina, Latinx conservation and environmental champions across the nation. Green Latino has an active membership of members in Texas, and our members, their families, and communities are affected by language barriers. We appreciate that TCEQ addressing alternative language requirements as they have been historical barriers to public input in air, water, and waste process. As a longtime public educator and advocate, I can tell you that having translations is imperative for equitable, positive, and inclusion participation. Also a sense of altruism in the community, a selfless concern for well-being of others. The public notice allows the public to become aware of permitting actions and gives communities the opportunity to be involved and assess how issues will affect us. So we may enhance the permit terms requisite for the protection of their health and their communities. Although the process rulemaking takes some valuable steps towards increasing participation, the final rule put forth by TCEQ still maintains barriers that negatively impact alternative language Texans and does not provide full equitable access to the public input process. The rule must address some issues at hand before it is approved, and some of them have already been spoken to today, which I'm grateful for. Some of them are translation using any resources that does not ensure accurate translation, and it places the burden back on the public. So that really needs to be addressed. The current language removes TCEQ and applicants from responsibility for mistakes. In the case of any discrepancies between English and non-English versions of a document that the English document controls, meaning that the error or erroneous information is allowed in translated documents and English documents are considered the dominant. It does not provide alternative language response to comment. And that needs to be really addressed in order for communities to feel heard, which is really important. The required plain language summary does not provide health impacts of proposed permits, only requires language over while the permit protective of human health and the environment. How can people make a decision if they want or do not want a facility if they do not know the potential damage to their health? It has the executive director can choose if the commenter is capable of understanding and participating. No definition, guideline, or examples of what constitutes as full participation is provided in the rule. I hope some of these and the other comments can be considered, and that you do use some of the community members that are here today as resources to ensure that there is an equitable and just rule and before it is adopted. Thank you.
Thank you. We appreciate your comments. Ms. Smith?
Juan Paras.
Good morning.
Good morning. Can you hear me?
Yes, sir. Thank you.
My name is Juan Parras, Director of Texas Environmental Justice Advocacy Services. The organization, along with Sierra Club that filed the lawsuit on language justice. And I would first of all like to thank all of the previous speakers in supporting the language justice issues that we have, not only here but throughout the nation. And the other thing that I want to mention is that, you know, bilingual education was passed in 1968 for a reason, you know, so that everyone could get a good education regardless of what language they spoke, but primarily focusing on those that were limited with English proficiency. So we've come a long ways, but we need to improve in what we're doing on environmental justice issues, on permitting issues that are held in communities that are still not proficient in the English language and need translations. So I think we hope sincerely that you will move in the right direction to reconsider making all those changes that the other speakers have addressed. And I'm not going to go into that. But I am hopeful that as a state commission that you will realize that there's a lot of things that go through the TCEQ that needs to be translated because of who it impacts, and those communities need to respond in the best way that they can, and they are only going to do that if they understand what you're trying to do, and they are informed in their language so that they can address those issues. Again, I want to thank you for your time, and I hope that we will continue making changes as we proceed and moving forward, because I know that a lot of times, when decisions are made or policies are implemented, that there will be touch-ups that need to be done to make it as perfect as possible and equitable. And I thank you for your time, and I thank all the speakers that are addressing this, because it is not only a local issue in our state, but it is a national issue when it comes to permits throughout the country. Thank you, sir.
Thank you. We appreciate your comments. Ms. Smith?
Araceli Ramos.
Good morning.
Hello. Good morning, everybody. How y'all doing? Hope your day is going great. I know it's a tiring meeting. I wanted to appreciate for listening to us. My name is Araceli Ramos. I am an ambassador for Coalition Environmental Equity and Resilience. I am a leader of East Alton Community, engineer, volunteer, and I am a mother of 5 children. The area where I live is probably, I would say 98% Hispanic, Latino, and I'm very hurt from my heart because I feel like we are left out in language justice. Not too far from my community, it was a company with a cement company that was letting a lot of air pollution into our community. I started having breathing problems in my children as well. I have 3 children with asthma. There was no information in Spanish. And I personally will tell you, because I speak with the community, they are scared. They are afraid even to speak to y'all, to say our health is getting worse. We don't have a voice because we are scared to speak to the commissioners. But in behalf of all my community, I want you to think a moment and please listen to us. They don't know when there's toxic. They don't know when they're breathing bad airs because they don't understand English. I learned English, but not every single person is going to take the effort to do it. They're not going to break that cycle. There's other Vietnamese people who don't speak the English, and they've been left out with that important information about the air pollution, the water. When the water is not drinkable, they don't know. So what are they doing? They're drinking toxins. They're smelling this bad air that's causing cancer. It is very sad how our community is ending with really bad health. Imagine yourself to live in another country where you will not understand the language, and your kids were sent to school, and your kids will have to translate for you. Will you think it'll be the same? No. There will be a lot of information missed from your children to you to translate, or other people that will translate for you, because they don't know the right vocabulary words. They don't know the right information.
That's 3 minutes.
Thank you for your time. I appreciate.
Thank you. We appreciate your comments. Ms. Smith?
The next group of individuals I'll call don't appear to be logged on to the webinar, but I'll call just to make sure that they haven't had the opportunity since I got this last message. Carol Smith.
Are you there, Ms. Smith?
Chairman, I still do not show her logged onto the webinar.
Okay. Let me check in with Ms. Demasi, just to see if you're doing all right with the translation piece of this, and also whether any of these people that Ms. Smith is identifying now might be on a separate line that you have access to.
Thank you. Thank you, Mr. Bernerson. I'm double checking right now. As of right now, we don't have anyone on the line, but please give me 2 seconds. I'll check again.
Thank you.
¿Alguien en la línea de español que necesite ayuda o que necesite hacer algún comentario? No response, Mr. Bernerson.
Thank you, Ms. Demasi.
My pleasure.
Yeah, Ms. Smith, why don't we run through the list of names, and we'll just see if any of them have been able to log in here.
Camille Boyd. Magali Rojas. Dolores Magruder. Irma Marshall. Murtala Tristan.
All right, so I think we've made it through our list of interested persons, correct?
Correct.
Okay. Let's now move on to OPIC. Mr. McWhirter.
Good morning. OPIC appreciates the agency's intention to expand opportunities for meaningful public participation in the permitting process. We acknowledge all the effort that's gone into each step of the process that was initiated after the Commission granted the 2019 petition for rulemaking filed by Texas Environmental Justice Advocacy Services and the Sierra Club. We support this rulemaking's overall goals of improving the effectiveness of public meeting notices and engaging more members of the public through the addition of alternative language requirements. In particular, we support the notice provisions intended to reach affected communities when there's no available newspaper in the required language, the provisions regarding alternative language application summaries and posting of these summaries on the Commission's website, and the provisions about public meeting notices and the availability of interpretation services. With that said, there are some changed provisions in the rulemaking presented for adoption that we are less enthusiastic about. Regarding when translations of the response to comments are required, OPIC prefers the version of 39.426E as originally proposed, rather than the version now before you for adoption. If there's a nearby qualifying school with a bilingual education program triggering Section 39.426 applicability requirements, and notices have gone out in a certain language, and comments have been received in that language, we prefer the rule expressly require a response to the commenter in that language. Also, we have some reservations about the reliability of all possible tools to translate complex technical and legal documents effectively. If the rule is adopted as proposed, we'll have to see how things go in that regard and evaluate the need to make future recommendations for change as we encounter any problems with that. That's the extent of my comments today. We appreciate the consideration that ED staff gave to OPIC's written comments during the public comment period and all the work by everyone that's been done on this rulemaking. Thank you.
Thank you, Mr. McWhirter. Colleagues, I have some notes and some thoughts that I'll share, and then turn it over to you to share your thoughts. Just right off the top, I heard a concern about community members, not specifically Spanish-speaking community members, not knowing how to reach the agency to lodge a complaint if they have concerns about conditions in their neighborhoods. And I also heard several of the commenters offer to be a resource to TCEQ, and I thank them. I appreciate that, and I'm going to take you up on it in a small way right now and point out that we have a web page in Spanish that describes how to contact the agency and lodge a complaint with the agency, register concerns about environmental conditions in your neighborhood. And I would invite you to link that to your web page if you host a web page, or otherwise communicate it with anybody who you think may have a cause to lodge a complaint, if they would be more comfortable doing that in Spanish. So that's just a small thing that I wanted to point out. Colleagues, I heard many of the commenters asked us to remand the matter, citing different concerns that they had, pointing out perhaps imperfections with the rule. I heard at least one commenter encourage us to go ahead and adopt the rule. This rule certainly does not perfectly solve the challenge of giving limited English speakers perfect access to the agency. I don't think it was ever intended to go quite that far. That's a tall order, so there are some practical limitations to how the agency can reach Texans who speak a multitude of languages. My suggestion is let's not let the perfect be the enemy of the good, and that we should go ahead with adoption. And I think a lot of the concerns will be worked out in the implementation of the rule. So I do think having a sufficient runway is appropriate to work out those implementation issues as much as we can ahead of time. And as Mr. McWhirter said, let's see how it goes. Let's evaluate it. Historically, our efforts to reach Texans who are not proficient in the English language have been iterative, and they're going to continue to be iterative. I think that about does it for my comments. But let me pause there. I think we have Camille Boyd, who's just now been able to join the call. So let me pause and allow her an opportunity to share her comments. Ms. Boyd, are you there? And Ms. Boyd, you might double check your line, make sure your microphone is turned on.
Chairman, I show she's self-muted. Ms. Boyd, if you can click that red microphone with the line through it until it turns green, that would unmute you.
Ms. Boyd, are you there?
She had it for just a second, but it went back to mute.
Hello, can you hear me?
Great. Yes, Ms. Boyd. Good to hear your voice. Go ahead.
Thank you for having me today. And as a resident of the northeast side of Houston, Texas, 5th Ward, I do agree with what you just said about the language barriers and trying to move forward to address that, to have everyone, since we are such a diverse city here in Houston, Texas, to have things accessible in different languages. And my thought was we need not only just English and Spanish, but maybe at least 6 languages, Vietnamese and a few others, to have it on your web page so that, you know, it'll be accessible. They can communicate with you about different challenges and equity disadvantages that we need your help with.
Well, thank you for those thoughts and comments, Ms. Boyd. Did you have anything else? I fear we may
No,
have.
sir. I just appreciate you having me on today. And if you'll take that in consideration, we will be very much appreciative. Thank you.
Thank you, ma'am. We're glad to hear from you. Thank you so much. Commissioner Lindley, what are your thoughts?
I've got about 2 points I probably want to really raise. First, I haven't gotten to thank Ms. DeMasi, so I thank her for her services today. I think everyone that's participated in this rulemaking matter, the amount of comments we got were significant. And, I just wanted to comment that I appreciate the quantity of comments we got, and I can't really articulate how much I appreciate the ED's work on the rulemaking getting to where it is today, especially Amy and Adam. I think they've worked long and hard on this one. I wrote down exactly what you said because I think it's a wonderful quote that let's not let perfect be the enemy of good here. I'll just come out and say right now, I would be comfortable moving forward with adoption today. The 2 points I guess I would want to make is my hope is that during the implementation time that the ED's office, and I know they have every intention, I believe, of doing this, but that they work hard to really try and address a lot of the concerns we've heard during the implementation. You know, whether these are just examples, whether that's defining some of the terms used that people are confused about. One comment I read in the comments I didn't hear today, but I think it's worth bringing up is I very much got a sense that there's a real concern about this new required plain language summary document that's now going to be required. And so I've mentioned this, well, I'll say it here now. I would, again, encourage the ED's office to look at how they can explain to both the entities that are going to have to produce those summaries and the public who's going to be reading those summaries. So all stakeholders really involved in the rulemaking, what exactly the expectation is for that summary. You know, my expectation, my thinking, and you know, I'm happy to be corrected on it, is that this document, I think in the backup there's 4 things listed on what it's going to cover. And so I do want it to be very plain language. I want the public to have an understanding of what's going to happen. And I don't see it being, I don't think it should be extremely burdensome on the people that are producing it. They need to be able to put that out, and it needs to be translated, and that way everyone has knowledge of what's going to be nearby. And not overcomplicate it, because that kind of goes against, I think what the point is to provide a basic, plain language summary of what someone's seeking a permit for. So I would just say, how the ED goes about doing that during the implementation, I don't want to dictate, but, you know, in my mind, I think pull up an old permit, provide an example of maybe what a plain language summary could look like. If that's even feasible, I don't know. But anyway, I think I'll stop there. There were a lot of, took a lot of notes today on the comments we received. I think there will be a lot to work out during the implementation. And And I know the ED's office will work hard on that. So knowing that, I'm comfortable moving forward with adoption, and so I'll stop there.
Thank you, Commissioner Lindley. I'll just interject real quickly. It's my understanding that staff is going to be working on developing some templates for those summaries, so it'll be very clear for all the stakeholders what it's going to be, and that they're going to use the time between now and the effective date, the implementation date, to work that out, to have a stakeholder process and work it out. Commissioner Janeka.
Sometimes you have to fuel your ship on aspirations alone, and I think that this is a really commendable rulemaking for us to move forward with today in terms of making as thoughtfully as we can changes to process with a very forward-thinking and somewhat hypothetical basis at this time. And for us to respond to many of the comments today that we've heard today, calling on us to remand it to the executive director, continue to work on returning some of the earlier provisions or imposing other requirements, I think that we're engaged in a very intense conversation with all the stakeholders who would be impacted by these changes materially in their process of trying to seek and uphold permits from our agency, along with the community who have a very high interest and a very high stake in understanding intimately and credulously what that conversation is that takes place with us on both sides of this teeter-totter. And I think that on many of the counts where in many of the commenters' comments today, and I think OPIC's very helpful analysis and their characterization of their position, I think many of the changes that we see in the proposal before us today versus what was originally proposed seek to take potential pitfalls in that process and place it in the discretion of the executive director. I'm not that concerned with our executive director having some of this discretion and making these calls because they are subject to the court of public opinion and they're subject to our review. And I know that we are very responsive in considering both the material factors they're trying to balance to reach those decisions, but also that public interest and public view of how the end product satisfies the social contracts that we work in and around. It's not the legal documents that all the companies and entities that obtain permits from us count on, but they count on our credibility just as much as the public does. And so I think that it's appropriate to move forward today, and I will be giving a very sharp eye to the work product as the executive director provides templates, but also I will call on and second your request that you made to the offer of support and assistance from many of the activists and advocates that we've heard from today. Please help us apply a real scrutiny to the products that come out of this process as we begin a new level of public engagement. We're trying to bring in some additional activities, and I think we're very sensitive to where those additional activities bring in costs, whether monetary costs or costs of time. Adding length to the process is something that I think is very concerning to both proponents and opponents of permit decisions that our agency has to make. So I think that I'm very appreciative and sensitive to many of the concerns that have been raised, and I think coming back around to your observation, Chairman, and I can't agree more. Let's not let perfect be the enemy of the good, and continue forward here. I will ask that we consider hearing from the executive director once we're at some date past, perhaps between here and the effective date on implementation, hear about some of the templates that they've developed and getting a better idea of what using all available tools is perhaps a great degree of flexibility that's available to the public, that I can imagine that wide latitude getting winnowed down significantly once the executive director has started to put out guidance and better understood what tools that are out there that don't seem to serve the public or industry at all versus these other tools that do. I think we'll get a much better picture moving forward. So I would love to hear from the executive director, perhaps between here and the effective date, but also perhaps at 6 months or a year after the effective date kicks in and we begin to see permits that are subject to these new requirements, merely understanding how is the process working out. And I like the idea of having an implicit rulemaking assignment going on there as well. I'd love to very much hear from the executive director as quickly as they come up with revisions or tweaks to this proposal. As soon as they become aware of them, I think that I'd love to hear from them just on possible changes that might be necessary to respond to public or regulated entity comments or concerns. I think that that's very worth looking at closely, because this is a new space we're venturing into, and I'm eager to see how we answer many of these hypotheticals.
Great. Thanks, Commissioner Janeka. Anything else? I think we may be ready to entertain a motion.
I have one. I was trying to think if there was anything. We're not supposed to hear from anyone. We've heard from everyone, right? Okay.
We have.
All right. Well, I will attempt a motion then. I would move that we adopt new 30 Texas Administrative Code, Section 39.426, amendments to 30 Texas Administrative Code, Chapters 39 and 35, and corresponding revisions to the state implementation. Oh, am I reading the right? Yeah.
I think you read.
I'm not, yes, we're not talking state implementation.
Chapter 35 instead of 55.
Let me redo it. And I'll talk slow. I know I started to talk fast, then I slowed down, but I'll try and talk slow the whole time. I would move that we adopt new 30 Texas Administrative Code, Section 39.426, amendments to 30 Texas Administrative Code, Chapters 39 and 55, and corresponding revisions to the state implementation plan as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item 29 is consideration for publication of and hearing on the proposed redesignation request and maintenance plan, state implementation plan revision for the Freestone, Anderson, and Titus 2010 sulfur dioxide NACS non-attainment area. The executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Allison Stokes with the Air Quality Division. With me is John Minter with the Environmental Law Division. For your consideration today is the Executive Director's proposed revision to the State Implementation Plan, or SIP, to request that the United States Environmental Protection Agency redesignate the Freestone, Anderson, and Titus non-attainment areas to attainment for the 2010 sulfur dioxide National Ambient Air Quality Standard. The SIP revision provides 10-year maintenance plans for both areas consistent with Federal Clean Air Act Section 175A requirements, and also addresses the comprehensive emission inventory and non-attainment new source review certification statement SIP requirements provided under Part D of the Federal Clean Air Act. Staff respectfully requests permission to publish the proposed SIP revision, solicit public comment, and hold a public hearing. Thank you, and we are available to answer any questions.
Thank you, Ms. Stokes. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Likewise, thank you.
Ms. Smith, has anyone signed in?
No one has signed in.
Thank you. Mr. McWhirter, what do you think?
OPIC recommends approval for publication of and hearing on the proposed redesignation request and maintenance plan, state implementation plan revision for the Freestone, Anderson, and Titus 2010 SO2 NACS non-attainment areas as presented by the Executive Director.
Thank you. Colleagues, I think this is an easy one, and we can celebrate the dramatic improvements in air quality here, but why don't we publish it, get some comments, and see what other people think.
I'm in agreement.
Likewise, I would move that we approve for publication of and hearing on the proposed redesignation request and maintenance plan state implementation plan revision for the Freestone, Anderson, and Titus 2010 sulfur dioxide non-attainment areas as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 30 is the consideration of the agency's post-incident response actions related to the February 2021 severe winter storm, including plans to evaluate factors that impact public water system response and recovery actions. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Brittany Wortham-Pequel, Special Assistant for the Plan and Technical Review Section in the Water Supply Division. With me today is Carrie Michelle LaKyle, Deputy Director of the Water Supply Division. I am here to provide the monthly update for the agency's after-action review of Winter Storm Uri. The Public Water System Survey was closed on August 23rd. The agency received approximately 370 responses. 6 half-day roundtable discussions were conducted from June 29th to August 3rd. During the conversations, participants provided valuable insight into their specific experiences relating to both impacts and successes experienced during the winter storm, as well as their suggestions for potential actions and recommendations for rules, guidance, and training for the project team's consideration. Participant input for improving water system resiliency focused on the need for more training and the development of additional guidance documents. The project team continues to focus efforts on coordinating additional training events through the fall. The annual Public Drinking Water Conference on August 10th through 11th included multiple trainings related to resiliency, such as preparing for severe weather events, best practices for issuing bulk water notices, emergency authorization processes, asset management to prepare for the next disaster, and the new requirements relating to the statewide emergency preparedness plans. A resiliency workshop was held on August 17th to 18th and focused on lessons learned using present-day disasters to plan for future events. The workshop was advertised to all water and wastewater licensees. Approximately 100 people participated in this workshop. Attendees were also eligible to receive up to 10 water and wastewater continuing education credit hours toward their professional license. Plans are currently underway to schedule additional resiliency workshops to prepare for future severe weather-related events and the new statewide emergency preparedness plan requirements. The project team is coordinating with EPA's Water Security Division to deliver resiliency workshops. The agency is partnering with the EPA to provide a virtual workshop with an emphasis on power resiliency, which is scheduled tentatively for November. The workshop will focus on power outages and how they affect both water and electric utilities, and will include presentations by regulatory agencies and water, wastewater, and electric utilities, as well as a tabletop exercise. In conjunction with planning training events, the project team is continuing to study the information gathered through the survey, roundtable discussions, and literature review, and will begin to draft a proposal for consideration. The proposal will include recommendations to strengthen resiliency for public water systems, as well as what the agency can do to better assist systems prepare for and respond to weather-related disasters. Finally, the project team is determining which water system weatherization design standards and regulations from other states could be beneficial for Texas systems to include in the project team's final recommendations. That concludes our monthly update. We welcome any feedback that you may have, and we are available to answer any questions.
Thank you. I have none. I'm really happy to hear about the benchmarking to see what other states are working on. I think that's a smart idea too, in addition to everything else y'all are doing. Commissioner Lindley.
I agree. Great report, and it'll be, I guess exciting is the right word to use. It may be interesting to see what comes together as a proposal.
Commissioner Janeka.
Happy to hear we're now chewing on all the responses that came in from the survey. Hope that we can translate that into a deeper conversation moving ahead. Thank you.
Thank you. Ms. Smith, has anybody signed in to speak on this item?
Not on this one.
Thank you. Mr. McWhirter, what are your thoughts?
I appreciate all the hard work this project team is doing and always appreciate hearing the report. So thank you.
Thank you. No action is necessary on this item. So Ms. Smith, I'll ask you to call the next items.
Items 31 through 34 are for a closed session. The commission will not meet in closed session today.
The time is 11:54 a.m. and we are adjourned.